Ladies and gentlemen, the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Adam Matos. This is a criminal case, and Mr. Matos is charged with 4 counts of first-degree murder. The definition and elements of the crime will be explained to you later. It is your solemn responsibility to determine if the state has proved its accusations beyond a reasonable doubt against Mr. Matos. Your verdict must be based solely on the evidence or lack of evidence and the law that I will give you at the end of the case. The charging document that I read to you before you were sworn is not evidence, and it is not to be considered by you of any proof of guilt. It is my responsibility to decide which laws apply to this case and to explain those laws to you. It is your responsibility to decide what the facts of the case may be and apply the law that I give you to those facts. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful for you to understand how the trial will be conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what they believe will be presented during the trial. I remind you, what the lawyers say is not the evidence, and you should not consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other evidence and exhibits also may be produced into evidence. As I told the panel, if it is produced into evidence, it will go back with you in the jury room. So you don't have to memorize any piece of evidence. It will all go back with you. After the evidence has been presented, the attorneys will have an opportunity to make final arguments. Following the arguments of the attorneys, the court will then instruct you on the law applicable to this case. I will do so in writing with each of you having a copy of it. After the instructions are given, you will then retire to consider your verdict. You should not form any fixed or definite opinions on the merits of the case until you have heard all the evidence, the arguments of the lawyers, and the instructions on the law that I will give you. Until that time, you should not discuss the case among yourselves. I now instruct you not to communicate with anyone, including fellow jurors, about the case. No communication includes no email, text messaging, tweeting, blogging, or any other forms of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of the rules that I give you, notify the court personnel or my bailiffs at once about the violation. During the course of the trial, the court may take recesses and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell them that you are a juror on the case and ask them to stop at once. If they persist, leave that area at once and immediately report the matter to my bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are here in the courtroom. Turned off means that the phone or other electronic device is actually off and not on a silent or vibrating mode. You may use these devices during your recess, but even then you may not use your cell phone, electronic device, or any other means to find out information about the case or to communicate with anyone about the case or the people involved in the case. Do not take photographs or video recordings or audio recordings of the proceedings or your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or electronic devices of your own. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact number will be provided to you upon request. This case must be tried by you only on the evidence presented during the trial, in your presence and the presence of the defendant, the attorneys, and myself. Jurors must not conduct any investigation of their own. This includes reading the newspaper, watching TV, or using a computer, cell phone, the internet, or electronic devices, or any other means at all to get information related to this case or the people and places involved in the case. This applies whether you are here in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look up maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people or places involved in the case until your jury service is concluded. So do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using electronic devices. You must not use your phone, computer, or any other electronic device to communicate about the case. Do not send or accept any messages related to this case or your jury service. Do not discuss the case or ask for advice by any means, including posting information on internet websites, chat rooms, or blogs. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented here in the courtroom. If you investigate, research, or make inquiries of your own, I will have no way to make certain that that information you obtain is proper in this case. Likewise, the parties would have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge evidence being considered against it, and to present argument with respect to all evidence. Any independent investigation by a juror would unfairly and improperly prevent the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that will require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and of course, the taxpayers. If you violate these rules, you may be held in contempt of court, face sanctions such as serving jail time, paying a fine, or both. In every criminal proceeding, a defendant has an absolute right to remain silent. At no time is it the duty of the defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure. It is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said if he or she had been permitted to answer the question. During the trial, it may be necessary for me to confer with the attorneys outside of your hearing to discuss matters of law or other matters that require my consideration alone. It is impossible to predict when such a conference may be required or how long it will last. When such a conference occurs, they will be conducted so as to consume as little of your time as necessary for a fair and orderly trial in this cause. As I discussed about note-taking, if you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes. If you do not want to, that will be left up to you individually. You will be provided with a notepad and pen for use if you wish to take notes. That's what's in the envelope in front of you. Any notes that you take will be for your personal use. However, you should not take your notes with you when you leave the courtroom. During recesses, my bailiff will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, my bailiff will deliver the notes to me. They are immediately destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should only be used as an aid to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of another juror. Notes are not entitled to greater weight than each juror's memory of the evidence. Each of you have an envelope in front of you, and inside is at least one pad of paper, pens, and pencils. If at any time you need another pad, pens, or pencils, because you run out, just raise your hand. I have a whole drawer full over here. Each envelope has a number on it. It corresponds with your seat. When we take a break, you can do one of two things. You can flip over the notepad in front of you or on your chair, or just slide it back into the envelope so it's not seen by anyone else. When you deliberate, your notes do go with you into the deliberation room. I just don't want them to leave the courthouse. So at the end of the day, if you can slide your notepad into the envelope, that way we know whose envelope goes with what pad. 1, 2, 3, 4, all the way, and they'll go right back on your chair when we come back to start the next day. All right?